Oh, I know how mainstream media is reporting a new order by Judge Chutkan that just came out in the last few minutes. It's a win for Musk. It's a win for Donald Trump. It isn't. Let me explain to you what just happened. Why Judge Chutkan denied 14 states' attempts to obtain a temporary restraining order. I'll explain it in the context of a TRO, and I'll explain to you why, more importantly, on the merits of the case. On the merits of the case. The states have the better argument. Judge Chutkan just said it in a new ruling. I'm going to read to you the portion of the rulings so you know I'm not making it up. That's why you come here, I think, to Legal AF on the YouTube channel to talk about things in a truthful way, in an honest way, with an experienced federal litigator along for the ride. I'm Michael Popok. Let's dive in. So, headline. 14 states bring motion for temporary restraining order to stop Elon Musk from cutting off state funding and state contracts. Denied by judge. I mean, that's a big headline. That's not what happened. I mean, it is what happened, but it's not what happened. There's two big things that just came out of the order, which we knew was coming. The judge, to get a restraining order, a type of injunction, or an injunction, you have to prove what's called irreparable harm, right? It is the threshold issue for any federal judge to find that there's irreparable harm. It can't be prophylactic. It can't be, well, maybe if in the future, it has to be a real imminent danger of a conduct in the future that needs to be stopped or the person will be harmed. And that's sort of what was missing from the temporary restraining order application by the 14 states. They were like, if Elon Musk cuts off state funding, if Elon Musk cuts off state federal contracts. If Elon Musk gets rid of and hollows out this federal agency, it'll negatively impact the states, but without concrete evidence that it has and it will and it does. And that missing piece is why sometimes you just can't get in a case a temporary restraining order. I've tried hundreds and hundreds and hundreds of cases. In a very small subset, I've asked for a restraining order, a temporary restraining order, emergency restraining order, a TRO, we call it, preliminary injunction, early injunction. Usually it's just a case about money or about a declaration by the judge of rights. And in a small subset, you can go for an emergency application. And even if you lose on the emergency application, it doesn't mean you're going to lose the case. You just may not have that irreparable harm, that toothpaste out of the tube, right? That, you just can't unscramble the egg. If you don't have that level of damage and injury, you really have things that can be dealt with at a later time. And that's what the judge says. I have limited power when it comes to injunctive relief. I have limited inherent authority. And you got to come to me with irreparable harm. And she told them during the hearing on Monday, I just don't see your irreparable harm. I see your harm. I see your injury. I see the unconstitutional aspects of Elon Musk running amok within the government with a sledgehammer and an axe to funding, to offices, to federal employees. And I believe he's exercising and wielding that power. But I don't see it as an injunctive component where I can stop the harm. Harm will happen. I'll declare it's unconstitutional. And then you can get your injunction at the end of the case. That's sort of where we're at. She also took a moment to basically call the Trump administration a bunch of liars because they filed a short 4 or 5 paragraph declaration under oath from the director of the Office of Administration, the Trump administration personnel guy, who said, Elon Musk doesn't work for Doge. Elon Musk isn't the Doge administrator. Elon Musk is just a special advisor. And just because he has some power, because Trump listens to him, doesn't mean he has any kind of formal authority. And the judge says, are you kidding me? Not only are there news reports where he's actually himself, with apparent authority at least, firing these people, but in addition to that, he, in the executive order itself establishing Doge, it says all the department heads have to get permission from Doge and from the Doge entity and from Elon Musk ultimately in order to make hiring and firing decisions. And she said, I warn you, defense, that means you in the United States of America, you Trump, you Department of Justice, you can't lie to the court. You have to be truthful to the court. I'm going to read to you that as well. But the part that I want you to take away, you're not going to pick up on mainstream media, is that she is indicating, no, she wrote it. to the lawyers for the 14 states, don't come to me with irreparable harm. Don't try for even a preliminary injunction. Let's get to the merits of the case. Let's get to full-blown trial, and I'll probably grant your request at that time to declare that Elon Musk is unconstitutionally appointed, hasn't been properly appointed, should not be able to wield this power without checks and balance, and that's what you really want. Don't ask me for the thing I can't give you. Ask me for the thing I can give you. Let me tell you where I'm getting that from as we move in here. So we've got the order. And what she says is, look, here's footnote 1 about the lying. Defendants filed, this on page 2. Defendants, that's the U.S., Trump, filed a notice and declaration by Joshua Fisher, the director of the Office of Administration, responding to the court's questions during the February 17th hearing, in which he stated, neither of the president's executive orders regarding DOJ contemplate, much less furnish authority to order personnel actions at any of the agencies specified. The judge says, well, just look at the text of the executive order. It says new career appointment hiring decisions at each federal agency shall be made in consultation with the agency's DOJ team lead, and that no one shall fill any vacancies for career appointments without the DOJ team lead approval. At a minimum, the judge said, this language contemplates DOJ's authority over personnel actions. Defense counsel is reminded of their duty to make truthful representations to the court. What does that mean? Don't lie to the court. And what the judge says is, I get that you, states, want me to stop 11 categories of conduct related to Musk and DOJ, right? That ordering any changes to disbursement of public funds, extending offers on behalf of the United States that would bind the government to appropriations not authorized by law, canceling government contracts, disposing of government property, ordering the rescission or amendment of regulations. But you got to come to me with something that they've done this, that they have done this. So what she says in her restraining order is, you got to come to me with irreparable harm. It's a threshold issue. And a lot of what you, on page 6, she says, a lot of what you're telling me is about if Musk and DOJ do these things, if they cancel, pause, or significantly reduce federal funding or eliminate federal state contracts, but you don't give me the evidence that they have. Now, for those that think, oh crap, all hope is lost, no. What she then said is on page 8, this is why I think the states ultimately win this case, although not on an injunctive basis. She says on page 8, that said, plaintiffs, the states, raise a colorable appointments clause claim with serious implications. Musk has not been nominated by the president, nor confirmed by the U.S. Senate as constitutionally required for officers who exercise significant authority pursuant to the laws of the United States, bypassing this significant structural safeguard of the constitutional scheme, citing Supreme Court cases like Edmund. Musk has rapidly taken steps to fundamentally reshape the executive branch. Even defendants concede there is no apparent source of legal authority granting DOJ that power. Accepting plaintiffs' allegations as true, defendants' actions are thus precisely the executive abuses that the appointments clause seek to prevent. That's on the merits. That's why the judge at the end, that's why I'm telling you, she's signaling, she's winking. Don't come to me with this failed irreparable harm standard being met. Skip injunction. Let's get to the merits. Here's what she says. It is further ordered, after she denied the TRO, that the parties meet and confer. If the plaintiffs intend to move for a preliminary injunction, which again, they'd have to get over the same irreparable harm threshold that she says they can't get over. The parties shall file a proposed briefing schedule and state their positions on consolidating the merits with the preliminary injunction briefing by 5 p.m. on February 19th. That's the key. The judge is saying, don't come to me with irreparable harm because you can't make that threshold element out. Skip it. Go to merits. Go to the trial. Let's combine the trial. I'll give you an injunction at the end, which doesn't require irreparable harm. See, only before trial do you have to show irreparable harm. After trial, you just do an injunction. Doesn't require that component. So she's telling the plaintiff's lawyers how to do their case. By tomorrow at 5 o'clock, I'll be reporting back here on Legal AF about what happened next. But that, I want people to have more comfort. It's a loss in the sense that they went for an injunction that they probably never should have, but not a loss from the ultimate. You might have lost a small skirmish or battle, but they're going to win the war. and I'll report on it right here on Legal AF. Thanks for being here. Take a minute, hit the blue or the free subscribe button. Help us continue to grow this pro-democracy channel. It's that important. This is the Break the Glass moment. Be here with us on this channel that I curate. Follow me on the Midas Touch Network as well. So until my next reporting, this is Michael Popok. In collaboration with the Midas Touch Network, we just launched the Legal AF YouTube channel. Help us build this pro-democracy channel where I'll be curating the top stories, the intersection of law and politics. Go to YouTube now and free subscribe at Legal AF MTN. That's at Legal AF MTN.